This video explains some legislative bills that aims to improve the judiciary and delivery of justice in Nigeria. Now, let us look at these bills. A bill for an act to alter the Constitution of the Federal Republic of Nigeria to confer jurisdiction on the Federal High Court to try offences arising from violations of the provisions of the Electoral Act and any other related act of the National Assembly, HB 115, sponsored by Honorable Mukhtar Tolani Shagaya. This bill amends the Constitution to enable the Federal High Court to try offences arising from violations of the provisions of the Electoral Act. By virtue of Sections 145, Subsections 1 of the Electoral Act 2022, only magistrate courts, the High Court of a state, and the High Court of the Federal Capital Territory have the jurisdiction to try electoral offences. This bill seeks to extend this jurisdiction to the Federal High Court so that they can also try electoral offenders and thereby expand the forum for addressing such. A bill for an act to amend the Court of Appeal Act to prescribe the number of justices of the Court of Appeal, increasing the number to ensure speedy administration of justice pursuant to the constitutional provisions of Sections 217 and 237 subsections 2b of the Constitution, SB 37, sponsored by Senator Oji Uzokalu. This bill seeks to amend the provisions of the Court of Appeal Act to increase the number of justices of the Court of Appeal from 90 to 150. A similar bill before the House of Representatives proposes that in addition to increasing the number of Court of Appeal justices from 90 to 150, a minimum of 6 justices should be appointed for every judicial division of the court. The effect of increasing the number of judges is that additional divisions or branches of the court can be created to bring the court closer to the litigants, reduce the workload of the court, enhance its performance, and expedite the dispensation of justice. A similar proposal has been made to increase the number of Supreme Court justices from 21 to 31 for the same reason of increasing judicial manpower and responding to cases faster. A bill for an act to alter the Constitution of the Federal Republic of Nigeria, 1999, to strengthen the procedure for removal of judicial officers in order to guarantee the independence of the judiciary, HB 1354, sponsored by Honorable Patrick Umo. This bill seeks to alter Sections 292 of the Constitution to tighten the procedure for removing or suspending judicial officers. Currently, heads of courts can only be removed by the President or Governor on an address supported by 2/3 majority of the Senate or House of Assembly, as the case may be. Heads of courts at the federal level include the Chief Justice of Nigeria, the President of the Court of Appeal, Chief Judge of the Federal High Court, President of the National Industrial Court, Chief Judge of the High Court of the Federal Capital Territory, Abuja, Grand Qadi of the Sharia Court of Appeal of the Federal Capital Territory, Abuja, and the President of the Customary Court of Appeal of the Federal Capital Territory, Abuja. At the state level, they include the Chief Judge of a state, the Grand Qadi of a Sharia Court of Appeal, and President of a Customary Court of Appeal of a state. The bill proposes that the address for removal of heads of courts must be supported by a memorandum from the National Judicial Council certifying that the judicial officer sought to be removed was accorded the right to fair hearing and that a case for removal was established. The bill further adds that it shall be gross misconduct for any person to remove or suspend or attempt to remove or suspend or participate in the removal or suspension of a judicial officer through any means outside the Constitution. This is intended to promote due process in the removal process of judges and heads of courts. A bill for an act to alter the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to provide for transition of substantive heads of courts in Nigeria, HB 1230, sponsored by Honorable Kwamoti Bitrus Lowry. This bill proposes an amendment to Sections 238, subsections 4 and 5 of the Constitution dealing with vacancy in the office of the President of the Court of Appeal. It seeks to ensure that a substantive successor is recommended by the National Judicial Council by prescribing a single period of 3 months to allow for the next most senior justice to take over in acting capacity while mandating that a new President of the Court of Appeal is nominated within the same period. The bill further requires that where there is a potential vacancy due to retirement, the National Judicial Council shall forward a name 3 months before the retirement of the incumbent to the President of the Federal Republic of Nigeria for appointment as President of the Court of Appeal, subject to the confirmation of the Senate. And that's it for the judiciary bills proposed by members of the 10th National Assembly. Part 1.